Counsel, maybe we can move on to individual question now, and I'm sure that some of it will deal with remedy, which is the one area we haven't addressed yet. And in that area, your position on vacatur, that sounded to me to be fairly radical and inconsistent with, for example, what those of us who are on the D.C. Circuit would do 5 times before breakfast. That's what you do in an APA case. And all of a sudden you're telling us that no, you can't vacate it. You do something different. Are you overturning that whole established practice under the APA?
Yes, I acknowledge, Mr. Chief Justice, that the lower courts, including the D.C. Circuit, have, in our view, been getting this one wrong. They have reflexively assumed that vacatur is authorized under Section 706 of the APA. But what I would say is that they haven't reached that conclusion with.
I mean, this is a long. That's what the D.C. Circuit and other courts of appeals have been doing all the time as a staple of their decision output.
But they haven't been doing it with any attention to the text, context, and history of the provision. So it's not as though there are decisions out there that have really engaged with these arguments and come out the other way. Instead, it seems like this happened and came about because courts just reflexively transposed remedies that were available under special statutory review provisions, which do sometimes authorize vacatur, to the APA context writ large. And our argument is that if you actually drill down on the text of 706 and look at its context, and also look at the history of the APA, which was not intended to create any kinds of new remedies, but instead to simply provide for the remedies that had pre-existed the statute's enactment in the traditional forms of legal action under Section 703, it demonstrates that the courts have erred here.
How many cases would you say that we have issued over the past year, decade, whatever, where we have upheld decisions vacating agency rulings under the APA?
The court has
Thousands.
done it in a number of cases. Some of those involve special statutory review provisions, so I do want to box those off. But I acknowledge, yes, the court has sometimes affirmed decisions that
sometimes over and over and over again.
But also never with attention to the remedial arguments that we're making here. And I don't think it's ever too late for this court to give the statute its proper construction when you actually look at its text, context, and history. And I don't think